Please, Your
Yes,
Lordship.
Mr. Chairman.
My Lord, item number 30.
Thirty.
35.
Supplementary.
Four. Mr. R. Iravu, the learned senior counsel for the petitioner submits that he has instructions to withdraw the writ petition. And therefore,
Your Lordship, will
prays
it
to
be
withdraw the
given,
writ petition. The writ petition is accordingly allowed to be withdrawn. Yes,
will we be given the liberty to file a
With
fresh if so
liberty.
advice?
with liberty to file afresh if so advised. Stop. The interim order stands vacated.
Your Lordship. Much obliged.
Your Worship, I beg to mention item number three, admission. Here, I was allowed to file a,
Let it come as per the list. Let it come as per the list.
okay,
May I please, Lordship?
Yes.
My Lord, I beg to mention hearing item number 31. On behalf of Sobong Lajang, my Lord, kindly list the matter after 2 weeks. Ma'am.
Mr. E. Tibapong makes a mention on behalf of MS Subong Lachang, the learned government advocate, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly.
Much obliged. sir.
May I please, Lordship?
Yes, please.
Lordship, I beg to mention hearing item number 23. Lordship, my senior is indisposed, so I pray the matter may be kindly listed on Tuesday.
Mr. So-and-so makes a mention on behalf of Mr. T.P. Jamir, the learned counsel for the petitioner, and seeks adjournment of the case after a week. Prayer is allowed, listed accordingly. Okay.
Obliged, Lordship.
May I please, Your Lordship?
Yes,
May I please to mention item number 22. Your Lordship, let the matter come up after 1 week.
on the prayer of MS Livika, the learned government advocate listed after a book.
Worship of the petitioner, for the respondent, 5.
Okay.
Your Lordship, I also beg to mention item number 24 on behalf of AIME. 24, after 2 weeks, Your Lordship. Prayer or on behalf of AIME, item 26 and
Okay.
29.
Learned government advocate. Okay.
My lord, in regard to 26, my lord,
Please me.
this is the matter which is a very short matter. And my lord, we have some urgency there. Your lordship, the last occasion, at its entirety, your lordship heard the matter. And the time was short, it could not be completed, that's the reason.
Who is for the government?
Avitoli, Your Lordship, she's indisposed.
My lord, this message could have been transmitted to me earlier so that
Ah,
would not have been there.
at least you could have actually like communicated. Next
No.
time, be careful. Will start imposing cost.
On the matter, my lord, as your lordship will understand, the DRT matter order was passed without jurisdiction. There is no equitable mortgage created. Even, my lord, the land is not surveyed land. The government has accepted it. In view of that, my lord, there is no equitable mortgage at all. Ex parte decision was there. And therefore, without seeing all these things, learned judges passed the order that equitable mortgage.
DRT is ex parte.
Ex parte.
DRT is ex parte.
Ex parte. The entire order was without jurisdiction, therefore we came in writ petition before this one.
Okay, Mr. Sincere, give a date. If the government advocate is indisposed.
My lord, if it is indisposed, of course, very difficult to say
But
anything.
next time, please see that at least the other side is informed.
Yes, Your
No
Lordship.
party.
Make it November 21st. My lord, November 20th, is it possible?
20 November.
My lord,
Yes.
Monday where the single bench sits.
November 20. Yes.
Your lordship will be there. Since the matter was heard by your lordship.
I have not heard. I have just actually like extracted the gist from you.
Anyway, if it is possible, my lord.
Okay, on the prayer of the learned government advocate. Listed again on 2011-2022. Okay,
Interim may continue.
the interim order passed earlier shall continue till the next return of it.
Much. obliged.
Okay, Mrs.
Your Lordship, I also beg to mention item number 29 on behalf of AIME, after 2 weeks, Your Lordship. 29.
Maybe same order.
Item number 28. Lordship, for respondent number 4, 5, and 6. Lordship, kindly list this matter after a week.
4, 5, and 6.
Yes, Lordship.
I have no objection, Lordship. I'm for the petitioner.
Your good name
Lordship, Mr. Kachishi.
on the prayer of Mr. Misakachishi, the learned counsel for the respondent number
4, 5, and 6, Lordship.
4, 5, and 6. The matter is adjourned for a week.
Much obliged.
I'm for the petitioner, Lordship.
Yes. Okay,
Lordship,
Lordship, I'd like to mention item number 33 for part 2 hearing, Lordship. I'm for the primary respondent in this case, Lordship.
33 and
33, Lordship.
33.
Lordship. If this matter can be listed after 2 weeks for hearing, Lordship.
You're for the
Primary respondent number 4, Lordship.
respondent 4.
Lordship.
Okay, on the prayer of Mr. Moa Jamil, the learned counsel for the respondent number 4, listed after 2 weeks.
Much obliged.
Let it
Lordship,
come up.
30.
2 weeks. After 2 weeks,
Both consensus
my lord.
on the prayer of the learned counsel for the parties. List the case after 2 weeks.
March.
For admission. Item number 1.
May I please, Your Lordship.
Yeah.
Your Lordship, I'm yet to receive instruction on the amended petition, Your Lordship. The government have instructed, giving me an instruction that they want to file an additional affidavit.
You have amended the petition,
Yes, Lord.
so we give time to the
Lordship.
government. 2 weeks time
Yes, Your Lordship.
is given to the government advocate to file affidavit in opposition on the amended writ petition. Okay.
Much obliged, Your Lordship.
Item number 2.
Yes,
Lordship, here I'm yet to receive some more documents, Lordship, so kindly grant me 2 weeks to file reply, Lordship.
reply.
Yes, Lordship.
Your good name,
Mika Ichaya, Lordship.
Mika,
Yes, Lordship.
MS. Mika HIA. 6 for 2 weeks time to file affidavit in reply. Where is allowed, listed accordingly. Okay.
Much obliged, Lordship.
Item number 3.
Your Worship, here I'm supposed to file a amended copy of the affidavit. So I am facing some problem for documentation. So I'm very for a week time.
Well, what about the affidavit in reply? What is this affidavit in reply? What is the affidavit in reply?
It's to the affidavit in opposition.
Have you filed? Have you filed?
Yes, we have filed the affidavit.
And Mr. Imti, what
Actually, for post title amendment, so I have obtained the signature of the deponent, but I have
post
facing-
title?
Yes, I have permitted by the honorable court.
Okay.
So I have made all the amended copy, but filing, I'm finding some problem for documentation. So I pray for another week time.
Amended, you want time to amend what?
No, amendment is allowed, and I have to file the amended copy of the affidavit. My affidavit in opposition.
Amended copy of the affidavit.
Yes.
Mr. Imti Ipsum, the learned additional advocate general, submits that he may be allowed 2 weeks time to file amended copy of the
Affidavit in opposition.
amended copy of the affidavit in opposition. Prayer is allowed.
Your Lordship, there's an
The
interim in this matter.
interim order passed earlier shall continue till the next reasonable date.
Obliged, Lordship.
Item number 4.
May I please, Your Lordship?
Yeah,
I'm mentioning on behalf of Ms. Lucino for respondent number 6. Kindly grant 2 weeks time to file my reply.
no, you're for the petitioner.
Yes, Lordship.
Have you filed your affidavit reply?
To the
Your
government. No,
office
Lordship.
notes shows that a reply affidavit not yet filed.
No, Lordship. We have not filed, Lordship.
You will not be filing.
Lordship, we will file, Lordship.
So what is your prayer?
To file affidavit, Your Lordship.
Affidavit in opposition?
Yes, Your Lordship.
Oh. Then your affidavit. in
Meantime, I may
reply
be allowed to file reply, Lordship,
to the state.
to the state, Lordship.
Okay. Okay. Mr. Moajamir is allowed 2 weeks time
Lordship.
to file affidavit in, to file reply affidavit to the affidavit in opposition filed by the state. Stop. MS,
Wickets or no?
so and so,
Correspondent number 6. On behalf of Ms.
next I mention on behalf of MS Lucino,
Yes, sir.
learned counsel for the respondent number 6. And 6 for 2 weeks time to file affidavit in opposition. Prayer is allowed, listed after 2 weeks.
Obliged, Lordship.
Item number 5 and 6.
Please,
Yes.
Lordship. Lordship, may kindly see order dated 21/9/2023.
21/9.
Yes, Your Lordship.
Okay, 21/9/2020.
Second para, Your
Ah.
Lordship.
In view of the above, the matter stands adjourned for 4 weeks so as to enable to
third-
complete the process
para.
expeditiously.
Third para, yes, your lordship.
Ah,
So your lordship, the petitioner's case is under consideration. And your lordship, necessary.
what is your
step has to
case?
take-
Ma'am, what is your case?
For work charge regularization, your lordship.
For work charge regulation.
Lordship.
Third, MS so learned counsel for the petitioner, and MS Esmeri, the learned senior government advocate for the state respondents. The state respondents are further allowed 3 weeks' time to complete the process for regularizing the service of the petition listed after 3 weeks.
Your lordship.
Okay? Okay,
Item number 7.
May I please,
Yes.
lordship,
Yes.
my lord, I'm yet to receive clarification from the department, so kindly allow me 3 weeks' time to file affidavit. my lord.
clarification or affidavit?
Affidavit,
Affidavit,
yes, I'm yet to file affidavit, my lord.
expedite, this is to 2021,
Yes, my lord, for several occasions I have informed the department, but I'm yet to receive.
very good. If that is so, we pass proceed ex parte.
3 weeks' time I will grant it, my lord.
Had Mr. Majamir, learned counsel for the petitioner, and Mr. E. Tiba, the learned government advocate for the state respondents. Considering that this is a 2021 case and no affidavit has been filed, a last chance of 3 weeks is granted to the state respondents to file the affidavit in opposition. Stop. It is made clear that if no affidavit is filed on or before the next day, the case shall proceed ex parte against the government. Okay.
Much obliged.
Item number 8.
Please, your lordship.
Yes,
Lordship, here the pleadings are completed, so the matter may be listed. for-
reply affidavit, I filed.
Lordship, we won't be filing our reply.
Mr. So-and-so, you're the counsel for the petitioner.
Lordship, I, Jamir.
The learned counsel for the petitioner submits that the affidavit in reply on the affidavit in reply. The petitioner will not be filing the affidavit in reply. And therefore the matter can be listed for hearing. Stop, listed for hearing in the usual course.
Much obliged.
Item number 9.
Certain damage compensation was awarded to the petitioner, but without the knowledge of the petitioner, the respondent number 6 withdrew the amount, lordship.
Yes, what is the progress? Either we give a direction. What is the progress? Have you recovered?
Lordship, as per last, the order.
Have you
Direction was-
recovered?
Direction was given to the state to
You
take steps.
recovered the money from you.
Lordship,
Have you recovered, have you taken steps?
for the state to take steps.
Yes. You were supposed to take steps.
Lordship,
Have you taken any steps?
Lordship.
What is that?
Lordship, I'm allowed some time to take an instruction, Lordship, since,
You are coming to this court casually.
no, Lordship.
We impose course.
I have already
You are not
sent
taking steps,
instruction,
we impose course.
Lordship, till there I have not received any instruction from the respondent, Lordship. I'm allowed to take a, instruction, Lordship. So a few weeks time may be given, Lordship.
See, there is a direction passed by this court.
Lordship,
And then
next time may be given, Lordship.
I think next time we'll impose cost on you, not on the government, on you. We'll impose a heavy cost. You are intentionally ignoring the order passed by this court.
No, Lordship. Inadvertently, Lordship,
What inadvertence?
but I have.
You are paid to do this job.
Lordship. In fact, I have communicated to the respondent, but however, in written now.
You pay cost.
Because,
That's the first warning, you pay cost 5,000.
Lordship, since I have conveyed them, since the new incumbent has taken over the charge in the.
There is no excuse, there is no excuse.
So, through telephonically, I have been informed, Lordship, to take the step, Lordship. And till such time, Lordship, I have not received the.
Next time, we will not accept any telephonic communication.
Because the new DC has taken over the charge, Lordship.
You pay cost, you pay little cost. I think that'll serve your purpose. Mr. So-and-so, learned counsel for the petitioner. Mr. V. Jimomi, the learned government advocate. And Mr. Fuseko, the learned counsel for the respondent number
6, Lordship.
6. You also tell your client to get ready.
Lordship,
If not, next time we will pass
I've
orders
informed,
against him.
I've informed,
Please
Lordship.
inform him.
Accordingly, from the very day this order, this honorable court has passed, I have informed.
By the order dated 21/9/2023. It was directed that the state respondents shall take steps to recover the money wrongly paid to the respondent number 6. And disperse the same to the petitioner. Stop by the state order. The state respondents was also directed to file a report on the steps taken. Mr. V. Jimomi submits that. He may be allowed some time to take instructions from the state respondents. From the submissions made by the state government advocate. It appears that the learned government advocate is casually attending to the orders passed by this court. And has in fact not taken any steps to communicate the order passed by this court to the state respondents. Such casual attitude of the state of the learned government advocate is deprecated by this court. Stop. The learned government advocate is accordingly directed to pay a cost of rupees within a period of 7 days from today. Place the case after 3 weeks, on which date the learned government advocate shall comply with the order dated 21/9/2023 passed by this court and file report on the steps taken by the government to recover the money from the respondent number 6. Listed after 3 weeks.
Item number 10.
May it please your lordship.
Yes.
Lordship, here the state respondent has filed their affidavit in opposition, and lordship, there's a necessity to reply to the affidavit, so kindly grant us 3 weeks time, lordship.
So the learned counsel for the petitioner 6 for 3 weeks time to file affidavit in reply. Prayer is allowed. Listed accordingly.
Lordship, please.
Item number 11.
May I please, your lordship,
Yes.
I have received the counter filed by the state respondents. One to
Where's
four.
your reply? Six for
3 weeks, lordship.
3 weeks time. So don't what you calling the learned counsel for the petitioner 6 for 3 weeks time to file affidavit in reply. Prayer is allowed. Listed accordingly.
Lordship.
Item number 12.
May I please, lordship? Lordship, I may be allowed 2 weeks time to file my reply to the affidavit filed by the state respondent.
Mr. So-and-so, learned counsel for the petitioner 6 for 2 weeks time to file reply affidavit to the affidavit in opposition filed by the state respondents. Prayer is allowed. Listed accordingly.
Obliged, lordship.
Item number 13.
Yes.
Pray that I may be given 2 weeks time to file a reply,
Reply.
my lord.
Mr. Imtilongchak, the learned counsel for the petitioner is granted 2 weeks time to file affidavit in reply to the affidavit in opposition filed by the state respondents.
Much
By the
obliged.
state respondents?
No, Union of India.
By the Union of India.
Yes,
Prayer is allowed. Listed accordingly.
much obliged.
Item number 14.
This is a backdoor appointment, lordship.
Back door,
Yes, and
no
it's-
front door.
No. Lordship, on 21/12/2022, the name of the respondent has been published in the local dailies. Now, only respondent number 11, 15, and 23 represented by,
Yes, wait, yes, wait.
they have shown their appearance here in my,
Yes, wait,
Record.
yes, wait, okay. Yes, ma'am. Now, respondent number 4 to
30, Lordship,
34. These are the private respondents.
yes, private respondent till
4 to
34.
34.
35 is NPSC. 4 to,
NPSC is a pro forma respondent.
yes, Lordship.
Who appears for the private respondent?
Lordship, I'm appearing for respondent number 9.
9.
9. Then
Please, your Lordship. Lordship on enter appearance for respondent 11, 15, and 23.
11, 15, and
23.
23.
Lordship.
Besides this, no
Madam,
other
by
has,
means, by what means was the notice published?
through
newspaper?
local dailies, Lordship.
Local daily?
Yes, in the
Have you-
Morong
have you
Express
filed
and
affidavit?
Nagaland Post.
Have you filed affidavit?
Yes, yes, Lordship. My affidavit,
Has any order been passed? Stating a notice themselves?
Lordship, I don't recall it. I beg your pardon. Lordship, maybe please to pass a specific order because it's going to be more than a year. It's going to be a year.
Have you furnished the copy to respondent number 9? Have
Yes,
you finished?
Yes, Lordship.
When was the affidavit filed? 16 February. 16 February 2023. 16 February. 16 February. Notice is deemed served by order dated 23/2/2023.
Lordship, Lordship.
23/2/2023. Notice is
Lordship.
deemed served. So, Mr. Vijmomi. File your affidavit,
Lordship, Lordship.
or else
I'm yet to
we vacate the interim.
Lordship.
Have you filed your affidavit?
No, Lord, no, Lord.
File your this affidavit.
Lordship, my humble prayer, if I may be allowed 3 weeks time.
We
File my
will
affidavit.
grant you, but next date, if you don't file, we will vacate the interim.
Lordship.
You cannot sit over the interim and then go on extending the case for filing a affidavit in opposition.
Lordship.
We give you 4 weeks time
Lordship.
with a condition that the interim shall be vacated. If on the next date you don't file your,
Lordship, interim is in favor of the petitioners.
in favor of the
Yes,
petitioner.
Lordship.
Then I'm sorry.
Lordship.
Okay. What is the interim?
Interim is not to regularize or not to
Okay. Mr. Vijmomi, the learned government advocate for the respondent number, for the state respondents. Mr. So, for the respondent number 9, and Mr. V Koza
Lordship.
for the respondent number 11, 15, and 23.
23.
6 for 3 weeks time to file their respective affidavit. Prayer is allowed, listed after 3 weeks.
Much obliged.
Obliged.
Item number 15.
Purchase IA 43 of 2023.
What is the interim?
Lordship, that no promotion shall be given to the respondent 5 to 15.
And
based on
promotion
the
is given?
seniority list.
Promotion is given?
Yes, Lordship, respondent 5.
State,
Despite
who
this.
is for the state? Call your officer.
My lord, here, there is one writ petition is pending, connection to this matter. Here in regard to the IA, the state has no objection, but in the writ, we have not filed the affidavit.
You have promoted somebody in violation. Initiate so motu contempt. Either like you recall the promotion or you face contempt. Where's that interim order? Let's see.
Lordship, and if there is publicly-
Where is that order? Interim order?
Lordship,
Order dated 13/9/2022.
What is your IA? What is your IA?
Lordship, IA is filed by the respondent number 5. So seeking for striking of the name of the respondent number 5 from the present writ petition. IA 43 of 2023.
Order dated 12/10/2023. This is passed in which? Whether in the IA or in the writ petition? Have you filed your affidavit?
Lordship, will be
You
filing-
you show this order.
Lordship will be filing our reply to the respondent 5.
You have actually stated that somebody was promoted during
Yes, Lordship.
in violation of the
Respondent
interim
five.
order passed by this court.
Yes, Lordship.
Have you filed your affidavit to that effect?
We are going to file our IA for that, Your Lordship.
Mr. Tiba,
Yes, my lord.
you tell this officer to recall. You tell this officer to recall any order, interim or final, which is violated in invites contempt. You know that.
Lordship, in that respect, may I make a small submission, Lordship?
If it is violated, your submission will not matter.
Lordship, but let me apprise this Lordship. On what basis? Lordship, in 2003.
You please satisfy this court whether the interim has been violated. That's all, that's all.
Lordship, see, we are also one of the respondents here. The respondent number 5 has been promoted in this case. But Lordship, our promotion is petition.
I am not on that. I want to know whether actually your promotion is in violation of the interim order passed by this court. That's all. Simple as that. The other merit we will decide during disposal of the writ petition.
Let them file it.
Not let them file, this court will issue order. Who has been promoted?
Respondent 5, Your Lordship.
And this IA is for? This IA is for?
IA 43 is for the striking of the name of the respondent, number 5, from the present writ petition.
But he still enjoys the benefit of promotion in violation of this court's order.
Lordship, that is how I'm making submission. Order has been struck off by this court. However, Lordship, after that, the pronouncement of judicial pronouncement in that writ petition, my case have been found that no, since his case, the initial appointment of respondent number 4 has not been projected before the court. That is how the veterinary association, that veterinary employees association, themselves, they have submitted a representation to the government. Then thereafter, in the process of it, the government has regularized my service afresh, not as per the earlier order. Because earlier order that was not projected properly. It was taken as 2003, whereas my initial appointment was 1996, Lordship. So on that reasons, my regularization has been reconsidered afresh, Lordship. So on the basis of that, since on the basis of that, my promotion, I'm due for promotions along with others. That is how my promotion has been considered. Lordship, in that case, like the government, let the government also file a affidavit so that it can be clarified the issue.
Where is that interim order? Let's.
Order dated 13/9/2022.
In which case?
WPC 168 of 2022.
Order dated?
13/9/2022.
13/9?
2022.
Mr. Thipa,
Yes, my lord.
is the officer concerned aware about this order?
This order,
This 13/9/2022 interim order, have you furnished a copy of this order?
Yes,
to the officer concerned?
yes, my
Have
lord.
you furnished?
Yes, my lord.
And is the officer aware about this order?
Yes. ma'am.
Kindly instruct him. Madam,
So my lord,
you
kindly-
file your affidavit on Tuesday. We'll take up on Tuesday. You file your affidavit on Tuesday.
may I please, your lordship, my
Yes.
lord, kindly allow me 3 weeks time. to
Within
just-
that, you tell your officer to recall the order or we proceed with the contempt. Regarding your filing your affidavit in opposition, that's a different issue. We'll give you time. But so far as contempt is concerned, we will not take it lightly. Listed again on. 14th.
Lordship. Your lordship. Okay.
No, not the 7th. You file your affidavit, short affidavit that it has been violated.
Yes, lordship.
And you also annex the copy of the order by which he or she was promoted.
Yes, lordship.
Okay. We will at least tell the officers to respect the majesty of law. MS, your good name? So and so, the learned counsel for the petitioner is allowed. So and so, learned counsel for the petitioner shall file affidavit. Clearly indicating the violation of the interim order dated 13/9/2022 passed by this court. Listed again on 7/11/2022.
Lordship,
2022.
interim will be allowed to continue.
Pardon?
Interim.
The interim order passed earlier shall continue till the next return of it. Okay.
Thank you, Lord.
Much older.
Item number 16.
My please, your lordship. I'll be filing an additional affidavit, so I pray that 3 weeks may be granted.
Additional affidavit.
Yes, lord.
So for the petitioner,
Yes, lord.
have you filed your affidavit, Mr. Ma?
Yes, yes.
Mr. Subangwati, Walling? The learned counsel for the petitioner submits that. The 6 for 2 weeks time,
3 weeks, lord.
3 weeks time to file additional affidavit on behalf of the petitioner. Where is allowed? Listed accordingly. Okay.
Yes, lord.
Item number 17.
May I please, your lordship. Your lordship, in this matter, I'm yet to receive service copy, your lordship, from the petitioner.
Why have you not served service copy?
My lord, I've already given. And it must have been given in the AG office, in the government office.
No, your
There
lordship.
must have been some mistake in that case. I will serve again.
You are not supposed to serve one, you are supposed to serve.
Three. All the respondents, there must have been some misplacement in that case. I will serve again anyway, my lord.
The
Also, my
learned-
lord, here is
learned
what,
counsel for the petitioner
my lord,
shall serve the requisite copies of the writ petition to the learned state council within,
lordship,
Within?
today itself.
in the course of the day. Yes.
My lord, there is one small typographical mistake in the order that has been passed on 25/9/2023.
25/9.
Yes, a small typographical mistake, which in the second paragraph, third paragraph, on the last 4 line.
25/9.
Yes, it is
Which-
supposed to be 3,000, not 30,000, my lord. So.
Which one? Which one?
Third paragraph, last 4 line. In 2007, the fixed pay was enhanced to rupees 330.
1, 2, 3. Para 3.
Para 3, last. Yeah, para
Last-
3. Last 4th line.
1, 2, 3, 4.
Last
It is
four.
3,000.
It should be 3,000, not 30,000.
No, it is recorded 3,000 here.
Here it is written 3,000 or
Maybe some,
30,000.
typing mistake.
Typing mistake, my lord. So might be rendered correction in this today's order. As a.
So where is the need for correction when it is 3,000? What was the order passed?
The Lord of Books for the petitioner shall serve requisite copies of the weak petition to the learned government advocate in the course of the.
In the course of the listed after 3 weeks for enabling the state respondents to file affidavit in opposition. Okay.
Much obliged.
Obliged, my lord.
Item number 18.
May I please, my lord.
Yes.
Lordship, I'm yet to receive instructions, so can you grant me 3 weeks time, lordship?
3 weeks time.
Lordship, there is an interim passed
To
on
file-
14.
Affidavit in opposition on behalf of the state respondents. Stop. The interim order passed earlier shall continue till the next return. of it.
Much obliged.
Item number 19.
No, please, Your Lordship. Your Lordship, I'm yet to receive instruction, Your Lordship.
Okay.
So another 3 weeks.
Okay, ma'am. Okay,
Yes, Lordship.
MS. Viveka.
Lordship, my senior Mr. Super Jamir's name may be reflected the
Okay.
cost list.
MS Livika, the learned government advocate, 6 for 3 weeks time to file affidavit in opposition. Stop. Prayer is allowed. Listed after 3 weeks. Stop. The name of Mr. Supu Jamir's name as the learned counsel for the petitioner shall be reflected in the daily posts.
Much obliged, Your Lordship.
For orders, item number 20.
Yes. Who's for the government? No
Lordship,
government?
there is government, Lordship, respondent number 1, Lordship. So on last occasion, Sir Veto has accepted on behalf of.
Your Lordship, kindly grant 3 weeks time, Your Lordship.
You are handling the case.
No,
VJ Mom, Lordship.
Jimomi has forgotten his case.
you must be engaged in court to Your Lordship.
Lordship, for respondent number 3 to 5, Miss Apila Sangtam is appearing, Lordship.
3 to 5, they're the main respondents.
Yes, Lordship.
What about the union?
Unit, they are yet to appear, Lordship. We have already issued a notice, Lordship.
MS. Inauli? Makes a mention on behalf of V. Jimomi, the learned government advocate for the respondent number 1. Stop. None appears for the respondent number 2, 3, 4, and 5. Listed again after 3 weeks.
Much obliged.
Much obliged.
Item number 21.
Yeah, please, Your Lordship.
Yes.
The service upon both the respondents has been completed through Dusty as well as the registered post.
Have you filed your affidavit?
The other, yes, Your Lordship. We have files on the 4th of October.
Respondent number 1, 2.
Yes, your lordship.
Where is your affidavit? Affidavit dated?
We have filed it on the 4th of October.
Okay. This first order was passed only on 21/9.
Yes, your lordship.
Let us give some more time. Let us give some more time. 21/9. Okay.
Okay.
21/9. Awaiting return service report from respondent number 1 and 2. Listed again after 2 weeks. Okay.
Lordship.
For hearing, item number 25.
My lord, this is somewhat similar to item 5 and 6.
Item number
5 and 6.
of today's list.
Yes. So, my lord, this filed by my learned friend, Hasten Law in the Manaro. So I may be allowed to compare the notes what's. It's in the same department. The present petition, item
5
25.
and 6.
Yes,
5 and 6.
put all are PG concern.
So you take instructions and
My lord, that is what I'm asking for time.
25, correct?
Yes,
Item 25. Mr. Imti Longchar, the learned counsel for the petitioner, submits that he may be allowed 2 weeks' time,
my lord.
2 weeks' time to receive necessary instructions from his client. Prayer is allowed, listed after 2 weeks.
Much obliged.
Item number 27.
Yes, what is the matter about?
Your lordship, this contingency drivers, your lordship. The petitioners.
I think the matter is also pending before the division bench.
No, your lordship, it was disposed, your lordship.
Uh,
Now, in this case, what happened was these are both the petitioners as well as the private respondent, they are contingency drivers. Now, as per the seniority list, the private respondent is junior to the petitioners number 1 and 2. Now,
they are all contingency.
yes, they are all contingency, but getting regular scale of pay, your lordship, normal scale of pay. So the service of the private respondent was regularized ahead of those who are seniors. So agreed by that, we have approached this honorable.
Regularized by what means?
Regularized against a vacancy, your lordship.
No, by what means?
Your lordship.
For a method of interview?
No interview.
We'll tell the government to advertise all the posts.
Your lordship, secondly, in the division bench judgment, your lordship, as per the division bench judgment, everything has been discussed, your lordship. So if the ever direction, the regularization of the private respondent may be questioned set aside, and the judgment, the related case, which is WA number 6 of 2022.
Where is that judgment?
I have already, if I'm not mistaken, on the last occasion, I have submitted a copy of the judgment.
What is the operative portion?
Paragraph 30.
What is this? The posts are required to be filled up in terms of direct recruitment by the NPSC.
Yes.
Clause 1(2) of the office memorandum stipulates that it is applicable to those board charge and casual who have completed or will complete 30 years of continuous service after 1/3, meaning thereby that the right of the petitioner read applicant to be regularized would only arise after rendering the rendered 30 years of service. And at present, the petitioners are yet to complete 30 years of service, taking into account that the petitioner at present are not eligible. This court cannot issue a mandamus directing the citizen to keep the vacant post till the petitioner becomes eligible. And this court cannot issue a mandamus directing the respondent states to keep the post vacant till the petitioner becomes eligible. The respondent state would be at liberty to take such course of action as deemed fit. So you can be regularized only after 30 years, as per this.
Your lordship.
Only after
as per this,
completing
yeah.
30 years of service.
But so far as the filling out of the post is concerned, your lordship, the order, as per this order, if this honorable court may direct as per the, because this case and the instant writ petition, they are related, your lordship. So if your lordship may, while passing the order, direct that the decision of the division bench in this WA may be applied.
If it is
That is
applied,
all.
what happens?
Your lordship, it is now up to the department to take the normal course as per the office memorandum.
So that means actually to apply, to implement this division bench order
Yes.
without disturbing the appointment of the respondent number 4, respondent number 4.
No, respondent number 4's appointment should be questioned, regularization should be questioned, set aside, because it is. He has been regularized ahead of those who are senior to him.
When you are not eligible, how can you question the regularization? When you yourself, you are not eligible.
We are all.
Some mistake must have
but
been committed.
Your lordship, yes, if they are to consider it, your lordship, they are to consider, or if they are to consider a regularization, it ought to be
Say,
in
Mr.
accordance
Tongpo,
with the senior.
you are challenging the regularization of the respondent number 4.
Yes,
When you yourself, you are not eligible for the post.
he also is not eligible.
No,
So if
he
at all-
eligible or not, he being eligible or not, that's a different issue. But when you are not eligible, if you are eligible and if you are challenging, that's a different issue. But when you are not eligible,
Your lordship, in this case, your lordship, if it is to be, if the post is to be.
we
advertised
can,
also,
we
will
can,
not- will
we
not
can,
drop
we
the
can
same.
consider your submission, directing the state respondent to actually like regularize your service as per the direction given by this court, but we cannot
No,
disturb his appointment.
But your lordship, as per service jurisprudence, your lordship, seniors, juniors cannot be regularized ahead. of
I'm
the
well
juniors.
conversant with that. And as per
Yes, Your
service
Lordship.
jurisprudence,
So
those persons who
based
are
on
not
that-
entitled, those persons who are not entitled cannot challenge the rights of the others. I'm well
Your
conversant.
lordship, your lordship, my humble submission is, it is your lordship who will decide the matter. Your lordship. But my humble submission before this honorable court is when my.
You are the
seniors-
petitioner, you are the petitioner,
Yes.
that's why I am telling you. I am actually asking you, you first establish your right to challenge the
Lordship, then
regularization of the
In
respondent
that
number
case,
4.
yes, your lordship, your lordship. I'll
Whether
take
you
your
first
lordship's-
satisfy this court,
Yes.
whether you are
I-
actually
Yes.
eligible to be appointed or regularized in that post. If you are not, then you can.
Yes, your lordship, then allow me to take your lordship through the facts of the case and then from there I'll try to
Ultimately,
satisfy your lordship.
it will boil down to that issue, whether you are eligible to challenge. I have understood that the
Yes.
respondent number 4 is junior to you.
Yes.
He has been regularized.
Yes,
Okay, rightly
Yes,
or
sir.
wrongly has been regularized.
yes.
But what is your locus to challenge his regularization when you yourself, you are not eligible to be appointed to that post?
Your lordship, as per the fundamental rights, juniors cannot be regularized ahead of the seniors, your lordship. As simple as that, your lordship, my submission is,
That will apply
yes,
when you have a right to challenge.
we have a right to be considered against that post, same with the,
You don't
Private
have a right
respondent.
to be considered because you are not eligible.
he is also not eligible, your lordship.
That is for the government to decide. If he is not eligible, let the government strike up his.
Your lordship, I leave it to your lordship. I leave it to your lordship. But it would be in violation of the fundamental rights of the petitioners if it is, if this petition is dismissed on the ground that none of us are eligible
Yes,
for
Mr. Mohammed, what is your
regularization
right?
and
What is your right?
Your lordship, for regularization, we see the sincerity, the efficiency. All those things are considered. and
What about the
court
scheme?
We have done that.
What about the scheme? Your sincerity, your efficiency, your merit,
No.
okay.
No, your
We
lordship,
consider that. What about the scheme? What about the scheme? You yourself, you have framed the scheme. So whether you can violate the scheme.
no, the play of the petitioner, your lordship. That is why I'm saying. In the play of the submission of the petitioner, my friend, your lordship, what I'm saying is that we have regularized the private respondent, considering the entirety of his sincerity.
What is that entirety? What is that entirety
During his service.
in the
during his-
context of the scheme?
During his service.
In the
there.
context of the scheme. For some, you say that the scheme is not applicable. For some, you say that the scheme has to be strictly followed. What is this? We advertise the post. If at all. We quash and set aside the appointment, we advertise the post. We direct the government to advertise the post. If you don't want to follow the scheme, can't help it.
Lordship, the private respondent was regularized way back in 2021, your lordship.
It's all right. Let it be even 15, 16.
Now, my only question is where is the enforceable right of the petitioner?
That I have actually raised. I have raised that. I have raised that.
It is to be regulative of the department, your lordship, the government state.
The question of whether the petitioner has an enforceable right is one issue. The other issue is whether you have followed the scheme, constitutional scheme to regularize his service. You have not. That is most important. Yes. Submit. But I have made my observation clear, tentative. We'll question set aside. We'll direct the state government to advertise the post. Yes,
your
but
lordship, then.
submit, make your
Yes, your
submission.
lordship. I'll take your lordship to annexure A, your lordship. Page 14.
Annexure
A, your lordship, page 14, 1-4.
Let me first see your prayer. What is your prayer? Let us see.
Question, set aside time, page 10, it starts from page 10, your lordship, page 10. In the premises aforesaid, it is most respectfully prayed that your lordships would be graciously be pleased to admit this petition, call for a regards and issue rule calling upon the respondents to show cause as to why a writ in the nature of certiorari and or mandamus and or any other writ, order or direction should not be issued to quash and set aside the impugned order number so and so dated 29/7/2021. Number 2, direct the state respondents to consider a case for regularization of the petitioners and other similarly situated drivers based on the seniority list of fixed scale paid drivers under planning and coordination department in consonance with the direction of in judgment and order dated 8/3/2021. Now this
What
was
is this? What is this 8/3/20?
this was appealed in the subsequently appealed against, and the
Okay.
judgment in the WA was passed, Your Lordship. At the time of filing of the writ petition, the standing judgment was this, Your Lordship.
Yes.
Then-
Yes, please.
So my case was that in accordance with the judgment of the WPC 17/2020 and applying the provisions of the office memorandums which are in existence. That is my second part of the prayer, Your Lordship.
So this judgment and order 8/3/2021
Yes,
was
appealed.
passed in your favor,
Yes, Your
in
Lordship.
your favor.
Yes, Your Lordship.
And the respondent appealed.
Appealed, Your Lordship.
Yes.
So now, Your Lordship, Annexure A, here, this is the seniority list.
When were you appointed?
Your Lordship,
When were you appointed?
2002, 2005 onwards.
2005.
The petitioner number 1 was appointed on 1/5/2002. Petitioner number 2 on 1/9/2005. Then the private respondent was appointed on 31/3/2006.
So this 17/3/2015 will apply.
Yes, that was
Scheme.
my, yes.
That is the scheme that
Yes.
will apply.
Yes.
Yes.
So the brief fact from the annexure A itself, Your Lordship, it is very
Annexure
clear.
A.
Yes, annexure A,
Annexure A page.
page 14, Your Lordship. This is the seniority list of fixed scale bid driver under planning and coordination department.
This is seniority of fixed scale pay.
Fixed scale bay. All the petitioners as well as the private respondents, they are getting this fixed pay.
They are
scale
all
pay.
drivers. All
They are all
drivers under
drivers.
the planning and coordination.
Yes, all drivers.
Don't know, where is the serial? Petitioner serial in this?
Petitioner number 1 is at serial number 1, Your Lordship.
Serial number 1.
Yes, petitioner number 2 is at serial number 2. And then the private respondent, the other petitioners are junior to the private respondent, Your Lordship. But since all of them are aggrieved because the seniority list is not being followed, they have approached this honorable court. But
Where is how many petitioners are there?
there are 6 petitioners, Your Lordship.
Six petitioners. So
Yes.
petitioner number 2 is serial 2.
Serial 2, Your
Then
Lordship.
petitioner number 3 is,
Serial 5,
yes, wait.
just below the private respondent, Your Lordship.
This serial 4 is,
Serial 4 is the respondent number 3. Private respondent.
then petitioner number 4 is,
Serial number 5.
no, petitioner number 4.
Petitioner number 4 is serial number 10, Your Lordship.
Petitioner number 4.
Serial number 10. Serial 10, 11 and 12. 5 and 6 are 11 and 12, Your Lordship.
They are all getting scale of pay.
They are all getting scale pay, Your Lordship.
Yes, please.
And the impugned order, Your Lordship, is at page 34.
Excuse me for
Your Lordship.
5 minutes.
Hey, hello, my mom is okay. Chalo.
Submission later.
Ever na pa-pwede na. Ever na site pwede na dali tumano wala ko siya. Wait.
Yes, please.
The impugned order is at page 34, the last page, Your Lordship, Annexure D. Page 34, 34. This is dated 29 July 2021.
This is the order regularizing the service of the.
Yes, respondent number 3.
Yes, please. Read.
So this was a boss.
Please read.
Yes, Your
The
Lordship.
report.
This is dated Kohima, the 29 July 2021. In the interest of public service, Shri Vizo Chiro, driver under Planning and Coordination Department, is hereby regularized in the pay matrix level so and so per month, plus all other allowances as are admissible under rules from time to time in Nagaland with immediate effect. 2. The period of service rendered on contingent basis with effect from 31/3/2006 shall be counted towards the length of service for the purpose of pension retirement, and no arrear shall be admissible for the period of service on contingent basis. His seniority shall be counted from the date of regularization. The above regularization is made against the post vacated by Shri Krishna Bahadur Chetri, driver, who has retired from the service on superannuation with effect from 31/10/2019, post created white order number so and so dated 21/9/82. The above regularization of service is purely on temporary basis, subject to termination by serving 1 month notice from either side. So now, Your Lordship, this post, this vacancy is a subject matter of the writ petition. And the writ
The
appeal.
present.
Yes,
Present.
yeah, not the present, but the earlier writ petition, that is
Earlier-
WPC
earlier
17 of
writ-
2020. Yes,
Yes, wait.
yes.
Earlier writ petition.
In the earlier writ petition, which is the.
This is judgment
Judgment-
8/3/2021.
Yes, Your Lordship. This is where the vacancies are arose, 8/3/2021. In the first paragraph itself, the facts are laid out, Your Lordship. Your Lordship,
Well, Mr. Tongpok,
yes,
let us first see this WPC 17/2020.
yes, yes,
You had actually filed the petition.
yes.
Seeking
the
for what
petition.
relief?
Seeking for two direct recruitments, two direct appointments were made. In that case, in this case, in this 2017, 2 appointments were made against the vacancies, which were already there in existence, without considering the case of the petitioners who are already serving. So aggrieved by that, we have challenged the appointment of the 2 direct. The direction was given to consider our case as per the office memorandum, as per the existing OM. Now, aggrieved by that, the 2 respondents in this case, they approached this honorable court by way of the appeal, which is the.
Correct.
Yes. Writ appeal 6 of 2022.
And 15.
And yes. So this honorable the honorable division bench reversed the judgment of the single bench by passing the order, which the effective portion of which is at paragraph 30, Your Lordship. That is the present position. So since.
So the respondents in the writ petition continues.
No, they are gone. The court, so far as the setting aside of the appointment of the 2 direct recruit 2 appointees, the court did not interfere. The division bench did not interfere. But so far as filling of the vacancies are concerned.
Yes, the government was directed to go by the scheme.
Yes. So that is the.
Okay.
That is my simple case. Since this.
So, but this R4 is different person.
Yes,
R4
R4
is a different.
yes.
This is a subsequent development again.
Yes, subsequent development. So because of that, after the judgment by the single bench was passed, they regularized his service without considering seniors ahead of him. So agreed by that, we have approached this honorable court for quashing and setting aside that his regular in this writ petition.
So this is a new order. This regularization is a new order,
Yes, yes.
not connected with the previous writ petitions.
No, because we were all in the same boat in the previous writ petition. 2017, that 2000, that WPC 17. In that case, we were aggrieved by the appointment of the So since we are asking specific direction of this honorable court to direct the state respondents to go by the WPC, the judgment in the WPC 17 of 2020, Your Lordship. Now that has been superseded by the judgment in the WA number 6 of 2022. So
this WA did not disturb the order of the learned single judge so far as quashing the appointment. It was given to go by the scheme, as per the scheme.
yes.
Yes, anything more?
That is my humble submission. That is my simple case before this honorable court in the writ petition. Nothing beyond that, Your Lordship.
Okay. Yes, government. You have a lot of explanation to do. Some, Mr. Tongpok, some review was also there. Some review petition was also there.
Earlier, yes. Earlier.
Review
in the
was
writ petition.
Review was against for which order? Review
Against the previous order.
single bench.
Yes, single bench. The order previous to this.
May I, Lordship?
This week. That review.
Review was modification was made, but substantially the order was similar, Your Lordship. Approach this honorable court by way of the appeal.
That appeal.
Yes, yes.
Oh, against both the order passed by
Yes,
the
yes.
learned single judge as well as the
Yes,
order passed in review.
yes.
Yes, government. What is your submission?
Your Lordship, the main contention of the state respondent, Lordship will find in page 3.
Of
Page 3 of the state contract, Your Lordship.
page 3, which para?
Para 6. May I read it, Your Lordship?
Yes.
Para 6, page 3. That with regard to the statements made in paragraph 6, 7, 10, 11, 12, 13, and 14 of the writ petition, the deponent begs to state that WBC number 17 of 2020 was disposed of by this honorable court by judgment and order dated 8/3/2020. Subsequently, civil review petition number 2 of 2021 was filed by the private respondent number 3 and 4 of WBC number 17 of 2020, which was disposed of by this honorable court on 15/11/2021. As such, during the pendency of the said review petition, the case of Sri Wizo Chiro, respondent number 3 in the present petition, writ petition was regularized by office order dated 29/7/2021. It is also pertinent to state herein that Sri Wizo Chiro, respondent number 3 in the present writ petition, was never made a party in the earlier proceedings, nor did he proceed in the litigation. As such, his service was regularized.
That's all.
That's all, Lord Lordship.
Have you not justified why he was regularized? Finish. Just by reading this para, you have completely supported the petitioner. Finish. Nothing more, nothing less. You have not justified as to why actually this Vezo was regularized in service. You have not justified. You are only saying that during the pendency of the review petition, that person's service was regularized. By making this kind of submission, you are in complete support of the petitioner. What more?
That is what the instruction of the department.
Oh, that's the instruction of the department. Suppose the case of the petitioner. With this kind of affidavit, with this kind of instruction, you should have advised the government to only withdraw the regularization. That's all. Why put another burden on the court? So that's your submission.
That's my submission.
Okay, okay. Yes, what is your case, Mr. Mua? You are not supported by the government.
Lordship.
You are hit by the petitioner. What more?
Lordship, exactly. The state has already filed the affidavit. Now, on perusal of the affidavit filed by the state, Lordship, my case and scope of making submissions has narrowed down, Lordship.
Very much.
My only submission before this honorable court is, Lordship, there are only two prayers before this honorable court, challenging the regularization of the private respondent number 3, my regularization, Lordship. And it is very clear from the record that I was regularized against a sanction post, Lordship, though there was no selection process, Lordship. Now I cannot go beyond the record. The second is, Lordship, their prayer is to consider the case of the petitioners, all the 6 petitioners, against the vacant post, Lordship. Now, in terms of the office memorandum 17 March 2015, and this honorable court, but division bench of this honorable court, has already decided in a similar case, Lordship. Now, the observation was made at paragraph 30 of the judgment, Lordship, that the candidates should fulfill at least 30 years of service. And the record furnished by the petition
you forget that the petitioner has not completed 30 years.
Lordship.
You forget.
Lordship.
Okay. We are with you on that. We are with you on that. But at least try to satisfy this court as to how you were regularized. Because at least that obligation lies on you.
Lordship.
Now the government has failed. It is the government who has regularized. The government has not been, forget about the sentence.
Lordship.
The government has not even met one word.
Lordship.
Justifying direction.
Lordship. In fact, the government has stated that my serial number is at 4. I'm this.
Let us forget the serial also. Let us forget the serial also.
Lordship.
Let us concentrate on the constitutional scheme.
Lordship. Lordship.
If you are eligible,
Lordship.
It obviously means that even the petitioner number 1 and 2, they are eligible.
Lordship, I agree. Lordship.
Why discard their case?
Yes, Lordship. Lordship, if I may, Lordship, for all fairness, if this advertisement was maybe advertised in all the eligible candidates, the petitioners as well as the respondent may be allowed to participate, Lordship.
That will fulfill the
for all fairness,
scheme.
Lordship.
That will, and that is the limited prayer of the petitioner also. If his case is not to be considered under the scheme.
But I
then
have objection if they are to be considered against the post, Lordship. It has to be advertised, but not the petitioner should not be considered against the vacated post, Lordship. That is my humble prayer.
That we cannot, of course. That I think, given the learned counsel for the petitioner is not on that.
Lordship. In that case, Lordship, for all fairness, if it can be advertised and all eligible candidates, Lordship. So the question of seniority will not come into play, Lordship. I'll also participate, Lordship. And if the petitioners, we also participate and the eligible candidates.
See, you petitioner as well as but if the government is to actually make a regular appointment,
Lordship,
before any of the petitioner or for that matter, the private respondents, they fulfill the criteria.
Lordship.
Then against that regular appointment, the post has to be advertised.
Lordship.
Okay, we'll pass the
Lordship. Obliged, Lordship.
Yes. Heard Mr. Tongpok Pangoner, the learned counsel for the petitioner, Mr. Moa Imchen, the learned senior government advocate for the state respondents, and Mr. Moa Jamir, the learned counsel for the respondent number
3, Lordship.
3. Okay. That's all. We pass the order.
Item number 32.
Yes, Mr. Hiba.
May I please, Your Lordship,
Yeah.
in the last occasion, I was directed to furnish the APAR of the petitioner. It is here, my lord.
Then let the DPC consider the upper. Huh?
My lord, TPC has already considered. my lord.
Without considering this? Without
No, my
considering?
lord,
Lordship, it appears that the ACR is blank.
This is only in respect of the petitioner.
Petitioner, yes, ma'am.
Why this was not considered during DPC?
No, my lord, it is already considered. Your lordship may kindly see the.
Let's see the DPC.
No, my lord, affidavit filed by the respondent number 7,
No.
my lord. In that, one annexure is there, my lord. Your lordship may kindly see that one.
Affidavit filed by the respondent number?
7, my lord.
Affidavit to the writ petition. Where, page
Page number 35.
Where is the petitioner's name?
In serial number 2, my lord.
No, nothing apart, nothing is mentioned.
Yes, nothing is mentioned. But in that upper also, in the original upper also, there is nothing is mentioned in.
Why?
2000,
Why nothing is
16,
mentioned?
16 to
Good, at
17.
least good or bad, something has to be mentioned.
Yes, my lord, but
Why?
it is blank, my lord.
No, why it is blank? You file an affidavit stating why it is blank.
Your lordship may kindly see that upper of 2017, 18.
2016-17 blank, 2017-18 blank, 2018-19 blank, 2019-20 blank, 2020-21 blank.
Yes.
Who maintains the APAR?
TC, Deputy
TC.
Commissioner Mon, yes.
Let him file an affidavit as to why actually the APAR has been left blank for this 2016-17, 17-18, 18-19.
Worship.
Two thousand This first page, performance of annual format of annual performance assessment report apart for Group C employees. This is for which year? Nothing is mentioned.
That is April 2022 to
Give it.
23.
Give me. Take and give me. Take and give me. Just write down the year. Yes.
Oh, is it?
Why the initial of the reviewing officer is also not given?
Yes, my lord. Your lordship, kindly allow me to explain the remark, my lord. From April 2022 to 2020.
Let us come first 16 to 17.
Yes,
Please.
my lord.
2015 to 16. Let us come.
2015 to 16 is nil. There's no remark has been given by the authority, my lord.
No, there are two
Yes.
authorities, reviewing authority and
Yes. There's no signature and
reporting authority and reviewing authority.
yes. And 2016 to
Marks have
17.
been given
Yes.
and integrity very good.
Yes. But the remark in the
Where's the remark? Where's the remark?
last
Let us-
page, lord.
Signature of the deputy commissioner, no signature.
Yes, no signature.
Assessment made by the deputy commissioner of the district. What is the deputy commissioner supposed to be? Reviewing? Reviewing authority? Arey bhai, you study and come. Study all this and come. You have just placed this.
Yes, my lord, here only for 4 consecutive years, the remark is not being given. But from the April 2019 to March 2023, his remark is good and very good. But this was not considered, my lord.
What about the others? 5 years you have to consider.
Other years, they have not given any remarks, my lord. No signature from the deputy commissioner and there is no remark, my lord.
You make inquiry and come. Only after that we will tell you to file affidavit if necessary. Okay.
Lordship, the petitioner is aggrieved by submission of uncommunicated.
This court wants to know something from the government advocate. Let that be complied first. You take this, you actually see, you read properly, carefully, and then you kindly explain to this court.
Okay.
And if there is any deficiency, you ask from the deputy commissioner or the officer concerned as to why. As to why this was not done, why that was not done.
Okay.
And come with report.
Okay.
Only after that, maybe we'll see. We may have to tell you to file affidavit. Do you require this?
Yes, my lord.
Yes. And next time you kindly give photocopy also.
Okay, my lord.
By the order dated 12/10/2023, the learned government advocate was directed to produce the annual performance assessment report, APR, of the petitioner. Which has been placed before this court today. However, the government advocate, the learned government advocate is directed to get more clarifications on the APR placed before this court. Listed again after 2 weeks.
Item number 34.
What is this case regarding that church?
Yes, Lordship. In that case, next statement you fix.
Yes, we will list it before some very good judges.
This is a bench 1 meter.
Pardon?
The person with petition, this is a bench 1 meter. So
bench
1 meter. Bench 1.
So we'll list it on
13. Lordship.
13. So listen, you'll get a good bench. 13. Listed again on 13, 11, 20, 23.